All right. Hello, all 96 attendees. On this webinar today, we are going to go through the 2024 law updates on a federal and state level, led by our CEO and co-founder, Ali. And we are so excited to have all of you here. Thank you for being patient as we were going through a couple edits, but we are more than excited to get started with you today. And with that, I will hand it over to Ali.
All right, thank you, Taylor. So good morning, everyone. Excited to be here with you. Happy Thanksgiving week. I hope for those of you that are traveling this week that you have safe travels. I know the weather on the East Coast is getting kind of crazy right now. But this is, we wanted to do it this week because I know for a lot of you, the offices are closed or about to be closed, and there's a lot of updates that are coming up, both at the federal level and at the state level, that we wanted to kind of go through and chat with you. And it is, although, we scheduled this in the morning on the West Coast, and of course lunchtime for the East Coast, there's a lot of you who have signed up for this, and so we're excited to get this out to you all, even if you're not live with us this morning, because you want to hear me during Thanksgiving week, and so it's perfect, perfect time for you to relax, eat some turkey, and listen to law updates as well. But let's go through this. There's been a lot of changes that have been interesting. We are seeing some trends that are occurring with COVID recently. As many of you have experienced, the compensation levels on average for your employees has gone up, for anywhere, whether you are a dentist, an optometrist, a veterinarian, a physician, you see, your employees' comps going up, and that is something that is very, very real. You guys are experiencing it right now. It is impacting your cash flows a little bit because employees are demanding more wages as a result of a lot of things, inflation, demand, and so on and so forth. But what's interesting is we are seeing a little bit of a variance occurring across the country. And this is one example that we got from a consulting friend of ours, showing the hygiene compensations around the country. And this is, from what they have told us, something that's very common across all the industries in healthcare. But it kind of shows you some of the states across on the coasts with higher compensations than those in the mountain region and in the Midwest, in the South. And so it's very interesting because it's something that we're all feeling. Now, the good news is that we are seeing a little bit of let up in this area. What I mean by that is that there are more employees who are getting back into the workforce. There's a lot less people quitting. I think people have gotten the news that people are being laid off, and that working from home isn't necessarily what is going to be the situation long term anymore for many companies. And so people are staying true to their positions. They're worried about losing their jobs, and so people are coming back to the workforce and staying in the workforce. And we are seeing a little bit of that in the healthcare world as well, where some positions like front desk, insurance coordinator positions, some back office jobs are a little bit more easily hired for, whereas a little bit more skilled positions like NPs, hygienists, front office managers, or just office managers are still a little bit harder to hire for. And so we are seeing a little bit of that now, which is great, because as we all know, the more the more employees are out there, the better. For those of you that don't know me, my name's Ali, as Taylor mentioned, and this is all I do. I help doctors across the country with their practice transitions, with their HR, of course, the hiring and firing of employees, performance reviews, estate planning. We do a lot of lease negotiations and things of that nature. So let's jump into it and talk a little bit about what we're going to go through. So what we're going to really go through in detail is changes, right? So the federal about state law changes and what's happening at the local level in some states, some solutions for that, a Q&A if we have time, but feel free to ask your questions throughout this presentation. One of our team members is there and she will answer your questions as we go through, so don't feel like you have to wait until the very end, and then we'll talk a little bit about resources and things of that nature as well. So let's talk a little bit about the federal law changes. So what is happening there? Well, there's a lot that is occurring, right, when it comes to this. The National Labor Relations Board is making changes to the standards because of a variety of things that have occurred over the last many years. And what really has happened is that there is a shift happening with employee safety. There is a shift happening with employment laws since COVID, and the reality is that these rules apply not only to the biggest companies in the country, the Fortune 500, Fortune 1000, but really apply to almost all businesses now, and so 90% of all the federal rules apply to small business owners like your medical dental practices as they do the Fortune 1000. And so it kind of gives you a sense of the fact that these rules are things that you have to pay attention to, even though a lot of times they are meant really to help protect against the largest companies taking advantage of their employees. And so as a result of that, what is the Stericycle ruling, and what is that? Here, what we're really talking about is that if a workplace rule, whatever that means, could be reasonably construed to inhibit an employee from exercising their rights, whatever right that might be, and that might be something that is presumptively unlawful, then that employee's rule could be deemed unlawful as far as it's concerned with regard to the legitimacy of that rule. Now, what are the kind of things that we're talking about here? Well, that could be, a lot of things, right? It could be restricting somebody from being able to take time off because of religious reasons, for example. It could be having restrictions regarding, maybe, COVID vaccines and things of that nature, which we saw a lot of over the past, few years. And so these rules, if they inhibit, someone's ability to, maybe, for their freedom of religion or their freedom of rights, or it could be anything having to do with maybe disability laws, accommodation rules, all of these things then could in theory impact, and your rules could be deemed unlawful. Now, why is this important for you? Well, it's important, and we're bringing it up because a lot of you are adopting new rules in your employment manuals and in your offices that may or may not necessarily be legal. And so what's really important is right at the outset is that you make sure you have an employment manual that going into 2024 that is compliant with all of these rules. And if you have customized your workplace rules to accommodate for employees, maybe sometimes working from home, if you have some insurance folks that are working from home, marketing people and things of that nature, or if you are in a position where you are still abiding by some of the vaccine rules and things of that nature, and you want to accommodate for employees that may or may not be coming in because of COVID or other disabilities that they may be incurring. This is the time to make sure that those rules are compliant with all of the requirements that the federal and state governments have going into 2024. So make sure at the outset you have a compliant employment manual. Now, where do you get them? Well, you can get them from a couple places that are truly trusted resources, right? So, and there's a couple places that are not that we're going to talk about. One is if you go to a law firm and you spend, $5,000, $6,000, $7,000, they will create a employment manual for you. Now that is, as you know, I mean, this is not something law firms like to do. My own law firm doesn't like to do it. Many, dental medical law firms don't like to do these because it's very time consuming, it's very expensive, but they are a trusted resource and they can probably put one together for you. You can of course come to HR for Health. We have our compliant manuals that are compliant across the 50 states. We will help you customize it. If you have your own policies that you want incorporated into your manual, we can help you do that as well. That is another trusted resource. Now, what would I stay away from? Right now, this is not necessarily, these manuals that we're going to talk about are not necessarily bad, but they're not necessarily proper for you as a medical dental practice. And those are manuals that are coming from payroll companies. Okay, remember, they're giving you the same employment manual that they're giving to any other small business. It could be a dry cleaners, a coffee shop, whatever, right? Those don't have the same rules as you, right? They have sometimes more obligations and sometimes they have less obligations, but they give you these templates and they tell you to sort of go with it, you not realizing what is required and what's not required for you to have in your practice. Then that's where the gaps occur, or you make changes and they're not overseeing those changes, and then you could be inadvertently changing these rules. Okay, so very, very important that if you are going to get a manual, you don't necessarily get one from them. The other source that I don't want you to get a manual from, and we see this a lot, is getting it from a friend or a colleague, right? So you don't know where theirs came from. You don't know if it's valid. It may look good. It may be, it may seem like it's valid, but just because your colleague or your friend has one doesn't mean it's necessarily the right one for you. Sometimes different counties have different rules, different cities have different rules, different areas in the state, have different obligations. I'll tell you a perfect example of this. Happened just very recently, where we had a doctor who called us and said that she had gotten a letter from a lawyer because she was not paying minimum wage correctly. Right now, you might imagine, minimum wage. I mean, that's low, right? It's minimum wage. I mean, how could she not have gotten paid her employees at least that much? Well, what happened was that she, in her county, the minimum wage rules were higher than the state minimum wage laws, which is the case in many parts of the country. So this, the federal government has their minimum wage, the state has their minimum wage, and then sometimes cities and counties have their own. Well, she had gotten an employment manual from a colleague in a different part of the state who was following just the state rules. They didn't have their own minimum wage rules, and she just followed that, not realizing that that her county had different rules, and she was underpaying her employee by 25 cents an hour. And so you can imagine how devastating that can be, for an employee when they find out, but then two, when they go to a lawyer, and then all of these rules and all these penalties and fines can come out. Now you might say, well, what about her payroll company? Didn't her payroll company catch it? Nope. Remember, payroll companies, their job is just to process payroll. They're not doing anything when it comes to compliance, right? Okay, what about her practice management software? Nope, right? That time clock and practice management software is just meant to track time. It's not meant to be fully compliant. And so a lot of doctors are relying on these products thinking that someone's overlooking over their shoulders to make sure everything's compliant, and they're not, right? They're not. So that's why HR for Health is so important in that regard, because we're making sure from the outset that you are compliant, right? So just use that example that I just gave you as, or that story as I just mentioned, as an example of how things can go wrong really, really quickly. And unfortunately for this doctor, the legal, costs are great. So, thus far, because of the fact that she made this small inadvertent mistake. And so, of course, that's not going to happen again. She's going to be on HR for Health and whatnot. But, at the time, she didn't even know she was not compliant. All right, let's move on to some other technical requirements the federal government has. The I-9, that's the immigration document. So you do need an immigration document, a new I-9 for all your employees. This actually went into effect on August 1st. Of this year. So any new employee that you've hired should have been given this new I-9. And so just please keep that in mind. It's always good practice, especially if you don't feel like you have all the new hire documents and things of that nature that you need. And depending on where you are in the country, it could be as little as 12, 13 documents, or it could be as high as like 17, 20 plus documents, depending again on which state you're in. So if you don't feel like you have those documents, you only have maybe 2 or 3 or 4, then make sure you reach out to us and we'll make sure you get taken care of on this front. But the I-9 is an immigration document. It's super, super important. It is a felony in many parts of the country to hire someone that's an illegal immigrant, meaning they are not authorized to work here. So believe you me, you don't want to go in front of your respective state boards explaining why you hired someone who's not authorized to work in the United States. And so just make sure you have an updated form that you're using. If you don't have all of your other documents, this is a great time, since we are approaching the end of the year, to update everything, and then more importantly, to make sure that you are getting the employees to sign all of your forms, because it's never too late to have them sign the updated forms. Okay. Now, that being said, there is, a sort of another way for you to verify, immigration status. It's called E-Verify. It's actually been in place for many, many, many years. For a long time, only federal contractors were forced to use it. If you work for the government or you sold goods to the government. Now, you can, as a private employer, you can also use it if you'd like. And so it's a good option. It's a little bit slow. It's a little arduous because you have to, you have to register and you have to put in some information. Sometimes it doesn't work, perfectly correctly. But you don't necessarily need to, but it would be really, really important if you, if you wanted to just make sure you're compliant. Now, assuming you don't want to use the system, the old rules still apply. What you primarily need is to have either proof of a social security number and someone's passport, or you can get a social security card and an original social security card, ideally, because there's a lot of fakes out there, and a copy of their driver's license, and then keeping that in your records will be good and fine as well. So just kind of keep that in mind. As we kind of move forward, the Pregnancy Workness Act, this is a new law that covers employers to accommodate any known limitations directly attributable to pregnancy, childbirth, anything having to do with medical conditions, pertaining to pregnancy. So why is this rule passed, right? And does it impact all states? Well, the reason this was passed, and this is why the federal government's getting kind of putting more of their touch and their hand on various aspects of HR law that they didn't always necessarily do before. The reason is because many states don't have the same protections that other states have. So there's great variances. Some states, California, Washington, New York, Illinois, Minnesota, Michigan even have very strict rules, that protect employees, especially if they're coming from pregnancies and things of that nature. Some other states don't, and so the federal government's trying to normalize this. And so for some of you, right, this Pregnant Workers Fairness Act isn't going to really make a difference, because your state rules are either already at that level or higher, right? So your state obligations are already there, and because they're already there, the federal rules don't really need apply in many ways, because your state rules are more stringent. For many of you, however, your state rules don't really touch on these kinds of pregnant worker rights and whatnot. And so for you, these things are applicable to you, right? And you do have to abide by them. And I'm going to give you some examples in a second. Now, if you have your phones, feel free to scan this QR code, and you'll get the poster, and it'll give you a little bit more information. If for some reason that doesn't work, let us know, and we'll get you the info in a little bit. So what are some examples of the things that this new act, that the federal government passed applies to? Well, offering additional, longer, flexible breaks, to rest and relax and whatnot, or maybe even use the restroom. So that's kind of one example. Changing work schedules to accommodate the employee, because of maybe morning sickness or post-pregnancy issues. Having other accommodations in the office that maybe you wouldn't necessarily think of, or maybe weren't things that your state required, are additional things that this act requires. Now, we recommend that you train your supervisors, your managers, everyone about these things, that they handle these requests very kind of uniformly across all the employees, and that they really know and understand that it applies to all the employees of your office, and how to accommodate them. And if they have questions, they pick up the phone and call us. Now, what are the things that you can't do, right? So you can't create accommodations without discussing it with the employees. You can't deny employees certain accommodations that they may be required. If you can't, really terminate somebody because they're asking for accommodations, and if someone brings this up to you, retaliating against them is never a great idea. Retaliation never in HR is a good idea. So try to avoid that if you can. But these are the kinds of things that this Pregnant Workers Fairness Act really is bringing into the forefront. And on top of that, there's other things that it brings into play that you may or may not be thinking about right now, which is the ADA, the FMLA, if you're a larger practice or a multi-practice owner. The Civil Rights Act can come into play as well. So just kind of keep these in mind. Again, remember, I'm not trying to make you into HR experts today. The idea is to give you enough information to know that when something is happening, for you to raise your hand and ask for help by calling our team or whatnot, and understanding kind of what the next steps are, so you don't make these mistakes. Okay, but no one's really talked about it right now. I think in the next month or so, going into the new year, we're going to hear more and more about it. But just remember, these are obligations that you have. Okay, something that's not really HR related, but it is important for you to know, is that the IRS has new regulations for filing taxes and other things. And the reason I bring this up is because of a couple of things. One is that obviously things are going more electronic. People are, the government, federal, state, are moving away from paper, filings and things of that nature, and everything's becoming just a little bit easier. Now, with that being said, by going more digital, it puts a little bit more onus on you as the business owner to keep really good records. And so it's a great idea to also go digital. So if you're doing your HR, on paper still, and you have old paper files and cabinets and whatnot, this is the time to change it up, right? This is the time to change it up and make sure that you're going digital, that you have a place where things are stored forever. It can't get destroyed by flood or fire or theft or anything of that nature. That way you have those records if they are needed. And because a lot of IRS documents and whatnot are required to be kept for 7 years, a lot of HR documents, is probably a good idea, especially with payroll records and tax records and everything else, that you also keep those for 7 years at a minimum. Now, obviously, HR for Health is all digital; it's all electronic. We can take all your documents. If you have paper documents right now, we scan them into the file, so you have them forever. It can never be destroyed. You have access as the owner of the business, but you can also give certain level access to your office managers and others, so that they can They can view what they should be viewing, they can upload what they should be uploading, but maybe they don't have rights to delete or alter or whatnot. Again, hugely important to to safeguard your data and to make sure that it's not manipulated in any sort of way. All right. So if you don't have your new hire forms, if you're don't have an employment manual going into 2024, if you're confused about some of these updates and how to incorporate them into your employment manual, let us know and we can help you do all of that pretty quickly. All right, let's now go to some state level changes that are happening. We're gonna go through some very, not all the states, of course, but some of the bigger changes that are happening. And so let's start with Colorado. In November of 2020, Colorado passed what is called Proposition 118. This basically created a state-run paid family and medical leave insurance program that ensured that all Colorado employees have access to paid leave and various other life events that may occur. So this could include birth, adoption, taking care of family members who might be experiencing serious things. So employers and employees through payroll fund these programs, and the employees will begin seeing these premiums deducted from or have been seeing these things deducted from their pay stubs in January of 2023, and starting in 2024, these benefits are going to be able to be used, really. So most eligible employees will be entitled to up to 12 weeks of leave, which is pretty much in line with what a lot of other states are doing. And people experiencing health complications due to pregnancy or childbirth can receive an even additional 4 weeks of leave. And so this is a pretty unique program in this sense, but for you who are in Colorado, this is super important to know about. All right, Minnesota proposed an earned sick and safe time law that requires employers to provide a form of paid leave to eligible employees who work within the state. So the law, which goes into effect on January 1, 2024, allows employees to earn 1 hour of sick and safe time for every 30 hours worked. Again, very common across the country. A lot of states have this, 1 for every 30 hours worked, up to a maximum in Minnesota of 48 hours per year. Okay, and now that can be increased if the practice wants to a higher number, but the minimum is the 48 hours per year, and it applies to all employees who work at least 80 hours in a year for an employer in Minnesota. So Minnesota is following many other states with who have sick leave laws now, and that have been in place for many years. All right. Illinois, has a new law as well. So this has introduced sort of an electronic notice requirement for employers with employees who don't, report physical workplaces consistently. It covers remote employees who travel to work. These things have to be posted electronically. It's important for us to bring this up, not because a lot of our medical dental practices have a ton of remote employees, but we are seeing a little bit more of that in the past few years, where some of your employees, especially front office employees sometimes who don't need to be in the office, insurance coordinators and things, things of that nature, accounts receivable, accounts payable. Some of you have these employees working from home. If you are a group practice or a DSO, then you may have even more of these, especially if you have sort of a semi kind of remote headquarters. So starting in January 1, 2024, you do have to post these notices that you see on your screen electronically and made it available to your employees. Of course, if you have HR for Health or whatnot, a lot of this is sort of done automatically for you. So just kind of keep that in mind. If you're a group practice, this is something that you can take advantage of. But if you have remote employees, just kind of keep that in mind. All right, California, who was the leader in passing sick leave laws many years ago, passed a new modified sick leave law that goes into effect on January 1 of 2024. And so there's a lot of sort of things that are changing. It basically has doubled the sick leave here in California from 3 days, 24 hours to 48. This is becoming, something that we'll talk about in a second. And this is very, it's going to probably follow suit across the country. But that being said, the more important thing to talk about with regard to California right now is that, and this is a little bit confusing because we've heard sort of different things recently. The non-compete laws in California have always been illegal, right? Now, that's not the case across the country. In California, you can't, limit your employees from competing against you if they want to, open up another office or do something. It's been compared to slavery here in California, so it's always been illegal. In various parts of the country, you can, compete against your employer, but not in California. Well, there's been sort of additional requirements that the governor passed now that make things even more penalty driven if you are an employer who has non-compete laws in your or non-compete language, I should say, in your contracts. So just kind of keep that in mind. If you have an independent contractor agreement or an employment agreement and you put non-compete language in there because you wanted to scare your employees from competing against you, now there could be civil penalties against you that the state brings. There could be additional penalties that the employee brings against you. It's become really, really difficult to have that language now. And so we are recommending that everyone, update their agreements before January 1. So if you have an associate with a contract, it's important for you to update that contract with a new agreement where you're taking some of this language out if you have any of it. This also applies to really reaching broad, covenants not to treat, in some confidentiality agreements may be pulled into that. So it's really become a really more broad issue where, if you have language where an employee can't, maybe take another employee and go, work at another office or whatnot, these kinds of things can also be deemed illegal. So really, really be careful of that. If you are not, if you are an HR for Health customer, please contact us because we have some promotions and some things that we're doing for our current clients to make this a lot less painful. If you are not an HR for Health client and you're listening and you need a new employment contract, let us know, because if we can do it for you at the law firm. If you end up becoming an HR for Health client, you get a significant discount on that. But remember, this is not something to wait on. You absolutely need to update your agreements before January 1, because as I mentioned, there are civil penalties now that could be put on you. This is basically the state coming in and penalizing you heavily if they find out about this. And so it's taking up the risk level a lot more. As I mentioned, this paid sick leave has changed in California. It has, pretty much, more or less, not exactly doubled, but pretty much doubled, and gone from, 24 hours, which was 3 days, to 5 days of 40 hours. Some states, now I don't want you to get confused, some states have 48 hours, as we talked about a little bit earlier and whatnot. California, was trying to go to 7 full days, but they pulled it back to 5 days, which is great at 40 hours. But this goes into effect in January. Now, what makes this tricky? What makes this tricky is for those of you who, well, let me take a quick step back, because some of you may not know how this works. So the way California sick leave has worked ever since it went into effect many years ago is that you get 1 hour of sick leave for every 30 hours that you work, okay? And it was capped at accruing up to, or you could limit your employees from using 24 hours of it in a calendar year, right? They could accrue 48, but you could limit it to them using 24, okay? So, and the idea there was that they would use 24 this year, and then in the early parts of the following year, they would have another 24 hours to use. They didn't have to wait for it to accrue, right? So you could accrue up to 48, but you would be limited to 24. Now, some of you, what you did there was you kept your paid sick leave, which was California law then, and you had vacation time, right? So you had two separate things. Some of you combined them, and that was what we were recommending. So to make it easy, you just combined it into something called paid time off, PTO. And basically, they had to earn at the same level, at least one for every 30 hours worked. So with this new rule, that has gotten a little bit more complicated. It's still one for every 30 hours worked. They can now accrue up to 80 hours, okay? But you can limit them to use up to 40 in a year, okay? So remember, they can accrue up to 80, but you can limit them to using, in this calendar year, 40 of them, right? 40 hours. Where it got tricky is that if you are doing PTO, paid time off, if they are earning their paid time off at a rate that is more employee friendly than one for every 30 hours. So let's say they earn paid time off at one for every 25 hours that they work, right? So that's more generous than one for every 30 because they have to work less hours to get that. There are some really complicated rules that you have to abide by that makes it very costly for you to be more generous to those employees. I don't know that the state really realized what they were doing here because they're penalizing employers for being more generous with their PTO with this new law, right? Because the penalty is that you, well, I won't get into why. If you have questions about it, just give us a call. But it is, if you're being more generous than one for every 30 hours, then you need to make sure that you call HR for Health or call our law firm or call someone who knows what they're talking about with regard to HR and helps you craft that, because otherwise it could be really, really expensive for you, and you won't realize it until you start analyzing your payroll data. And remember what we talked about earlier, many of you are feeling the cash flow crunch with higher wages and whatnot. And with this new California law, if you're not careful about how you set up your accrual for the PTO, your costs for your employees could go up significantly when it comes to paid sick leave, and you won't even realize it, further impacting your cash flow, So without, causing too much confusion on a webinar, if you have any questions about it, just give HR for Health a call and we'll walk you through it. But remember, the penalties become real, or it becomes very expensive if you're accruing at a rate more generous than one for every 30 hours, okay? So, please make sure, if you have questions, raise your hand, ask for help. We've got some really wonderful end of the year promos for those of you that sign up. Again, as I mentioned, end of the year is a great, awesome time to update all of your HR documents because everyone's expecting things to change. Everyone's expecting new, healthcare information and, all this stuff that happens at the end of the year. So it's a great time to update everything as a, if you don't have your HR house in order, because it doesn't seem as big of a deal than if you changed it suddenly, in the middle of the year when it seems a little bit more random. Okay. Now, what is the impact of a lot of this? Well, the federal rules, are changing. They switch up employee benefits, work hours, wages. It is creating sort of a tangled web of laws that you have to navigate, because you have, the federal rules that now apply to a lot of small businesses like yours. You got the state rules, and then you got a lot of county rules as well. And we don't know what's going to happen with the election next year. We don't know if a new administration is going to, change things. But under the current administration and under the current things that are occurring, the federal government's getting more involved with your business. and which is creating sort of this tangled web of laws that you have to navigate. Then you've got obviously the state rules that are changing a lot of the licensure requirements that you have to abide by with the employees. You have to make sure you're monitoring their leave, any and all retaliation rules. This is becoming a real issue since COVID. Obviously, retaliation was always existing, but it's become more pertinent because of the fact that people are being let go and sometimes retaliated against for various disabilities, not necessarily COVID related, but pregnancy and other kind of things. So you really have to monitor all of these rules carefully in order to do it correctly and not fall victim to it. And so this is where it gets complex. This is where your risk profile really goes up, because as you might imagine, these law updates, some of which we've gone through today, means that it's not just enough to know about it, you also have to update your files, you have to update your employment manuals, and more importantly, you have to make sure the employees sign on these, right? Sign these documents. We had a case just recently where the doctor had a manual created by one of these like third parties that does just employment manuals for doctors, and they sent it to them. It was in a nice box, and she never ended up giving it to the employees, had it in the staff lounge. Nobody ever signed it. No one ever followed up with them to make sure it was signed. They paid their couple $1,000s for the manual, and there was no follow-up on it. And so that's the beauty of why we created HR for Health the way we did. You will know if your employees have not signed your documents. You can follow up with them. And if they don't sign it, then you can, force them to sign it, by either writing them up or maybe even terminating them. So no, there's no gaps, right? And that's the issue with HR. We got to make sure there's no gaps, right? Because the worst thing is being brought into a lawsuit with all of these rules. Now, you might say, Ali, isn't lawsuits just part of the game? Can't you win with all this stuff? Yeah, of course, it is part of our country, right? There's a lot of lawsuits, and we can't avoid all of them. As you get bigger and your practice becomes more successful and the economy starts to kind of tank and people are left without options, we do see more lawsuits. But my goal is not to just win for you. Yes, we do win. We win a lot because we have so much documentation in HR for Health. But I don't want you to ever even be in that position. That is my ultimate goal, is I don't want you to ever get sued, right? Yes, we can win, but at what cost, right? So prevention is the key, right? Just like you talk to so many of your patients, prevention is the key. And it starts with education, and more importantly, it starts with knowing which of these apply to you, right? So how do we do this, right? So the solution is very simple, right? One is you've got to know what these law updates are. So for the many of you, the thousands of you who listen to these webinars over the course of the next couple of months, we see all the data from how many of you watch it, repeat watch it, forward these videos and things of that nature. You got to keep updated on these law updates. Now, we cover at a high level because it's important for you to know what they are, but the details of these laws is really what's important, and that's what we put in the employment manuals that we prepare for you. They're automatically updated. Now, remember what I just said, automatically updated for you every year per your state rules. You don't have to pay extra for it. You don't have to beg someone to do it for you. It is done for you, and then you get notified to push it out to your employees so they could re-sign it every year. It's a really great way of protecting your practice. Very simply, that's our goal, is to protect the practice, and we do it by making sure the employees are signing these things, right? So hugely, hugely beneficial. Time off tracking, great. Using our time clock, for clocking in, clocking out is step one, right? I had a doctor yesterday tell me, I use this practice management software's time tracking tools. It's like, great. Well, what else does the software do? No, that's it. It just tracks clocking in, clocking out. Okay, well, it doesn't track, vacation, sick leave, or PTO. Doesn't track when somebody needs to take vacation. Do they have any of that? How many days are used? Doesn't track correct overtime calculations. Doesn't do any of those things. Then it's really not worth its weight in gold. And right now, a lot of the laws that are being passed around the country are based on time tracking, right? They're based on time tracking because that's how employees earn their benefits is by working, right? So again, hugely important. Finally, you'll have access to our HR specialists. Now we have a whole team of rock star HR specialists who will answer all of your questions, no matter what they are, no matter how many times you call, right? How many times you call, and because that's life, right? I mean, we all know this. Sometimes, you'll go a long period of time, couple years maybe, and you don't have any HR issues, knock on wood, and that's great. And then suddenly you'll have, an issue and you have to call 5 times. Awesome. You don't get charged for any of that, right? You have unlimited access to the HR team for questions. Now, if the situation rises to a level where you need to talk to a lawyer, then you will be transferred to me or one of my team members here or another friendly law firm around the country who will answer your HR questions for you also for free. It's all included, right? When was the last time you talked to a lawyer for free? So you get a lot of that, right? You get a lot of that. Now, if God forbid you get sued or something happens, then of course there's going to be some legal charges. But as an HR for Health customer, you get 25% off of all legal expenses, Now, that also is not just limited to HR. You could say, hey, I need a lease reviewed. I'm buying another practice. I'm doing this, I'm doing that. All of that is included as well. So use that resource, hugely beneficial. But I want to end on, I think, the most important reason why getting your HR house is so important. Sometimes, when I first created HR for Health, it was as a need for HR compliance because so many of our doctors were being sued. It was born out of HR compliance. I mean, after all, I am a lawyer, right? I have to keep you compliant. But we've seen something very interesting happen, which is that when your team knows that you are taking their jobs very seriously, right? You're taking into account their overtime, their benefits, you're being fair to them. It doesn't mean you have to provide the best benefits ever, right? You provide what you can provide, right? What you can afford, health insurance wise, 401k wise, all those things. You provide what you can afford. And as your practice grows, you provide more, and if your practice is declining, maybe you provide less. But when the employees know that you're taking it seriously and you're trying your best and that the rules are the same for everybody and that you've got an employment manual that's fair, that they're clocking in, clocking out objectively, you're not being subjective, you're not, doing all the things that get you in trouble, that culture that you create of fairness is something that they respect a lot. And what we see is that those employees are less inclined to leave if someone down the street offers them 25 cents more or 50 cents more, because they realize the grass is not always greener on the other side. You might get paid more, but maybe you don't like the employees that are there. Maybe the doctor doesn't keep the office compliant. Maybe they're not following up with things. And so you're more likely to keep your team, happy and with you and growing than not when you're HR compliant. The other added benefit from a recruiting perspective is that your employees know a lot of other employees, and so they will recruit for you and say, oh yeah, my doctor's great. This is what we do. This is how we process time off. This is the benefits we have. They are your best recruiting tool because they can bring really awesome employees to your office, right? So again, hugely important to focus on that. It's people tell me, how do I recruit the best employees? Well, you recruit the best employees by taking care of your employees, right? The better your employees are, the happier they are, the more inclined they are to bring in their friends. Remember, no one, we're Americans at the end of the day, right? We're not in a socialist world, right? We like to work hard, right? Despite what people say about this, this current generation, all this, it's not, Americans work hard. We like to, right? This is what's in our DNA. But we also want to be respected. We also want to be paid fairly. We want to get the right benefits. And that's what we hear from employees, right? They don't mind working hard for you, but they want to be paid fairly. They want to have the right benefits, and they want to know that you care and you're doing the right things. And so that's your best recruiting tool, is take care of your employees, and they will take care of everything else, right? Your patients, your profits, and recruitment. All right. With a few minutes left, I think we have some Q&As. So if you have any questions, put it into the questions in the chat box below. I'll see if I can open this up and maybe ask some questions or answer some questions that you all may have. Yeah, so let me go through these. I don't even know if I can see it actually. Yeah, okay, here we go. And then, you know, again, as I mentioned, don't feel odd about asking you know, asking our experts, you know, at HR for Health, any questions that you may have. They are here for you, and they will answer any questions at all. And so before we get to that, because I don't know, Taylor, if you can see the questions, but I wanted to talk about a couple of things for you all before you leave. If you want to take a shot of this QR code, we have sort of a document we created that talks about what are the biggest issues that we see in HR in our practices nationwide. It's very data driven. I think you'll really like the information. And what we have noticed as a little bit of a sneak peek into the document is that tardiness is the most common employee issue that our offices have. And it's really kind of crazy because it goes to their psychology, right? If they don't want to, you know, be on time at the office, you know, what does that say about how they, you know, how seriously they take their job and their responsibilities? And this is a serious problem. They're a serious problem, and it usually impacts their performance, impacts patient happiness, impacts you know, impacts a lot of things. And so you know, this is something that, you know, we can help with HR for Health, because, you know, when it comes to our time clock and the various other things, it can really limit the tardiness issue. You can nip it in the bud very quickly. And then, you know, before we get to the questions, we've got one final really special, you know, announcement to make. Is we are changing the way, you know, medical and dental practices across the country are doing scheduling. We have launched our scheduling system right now, you know, that many of you can start to take advantage of, and we will roll it out fully to all of our customers, you know, in January. But basically, you can now schedule your employees on our system by visually seeing exactly who's working where. If there are gaps in the schedule, you can fill it in with a drag and drop system. And very exciting new product that we've rolled out. It's going to be something that is going to change the way many practices, you know, see their schedules. We want to make you as profitable as possible, and we want to make sure your schedule is filled. And so if there are any gaps, you will now see it. You'll be able to move employees around. If you have multiple offices, you're going to love it even more, because you'll be able to move people from different offices and fill in gaps that people are calling sick or whatnot. And in the future, we're gonna help you even recruit people into that may not, you know, be working for you, but that's down the road. So take a look at that as well. So Taylor, do we have any questions that I can answer, or has Lauren been able to answer most of them?
Lauren has gotten to quite a few of them, but there was one that I saw from someone named Janet asking specifically about the Pregnant Workers Fairness Act, and if it's appropriate to ask an employee beforehand what accommodations they might need, or do you wait for the employee to come to you first?
Well, I think it depends on the relationship you have with the employee. I mean, I think it never hurts to be proactive with the employee, I think, in terms of the accommodations. But if you don't want to necessarily have those conversations, I would wait on the employee to come to you and make the request, because they may not need accommodations. You know, some folks after delivery, you know, decide that they wanna come in and continue working the hours that they were working, and that's not an issue anymore. You know, but sometimes so sometimes they need the accommodation, sometimes they don't. But I think you know, being proactive is never a bad thing. But if you wanted to wait for the employee to request it, that's okay as well. So.
Lauren, you have gotten to quite a few of the questions. Are there any that you thought stood out and maybe we could talk about with the entire group?
Yeah, there's one that I saw actually. There's one that I saw that asked about the I-9. It said if an employee has an I-9 already signed, like an older version, do they need to sign the new one? And the answer to that is no. If they have an older one that you've signed and it's done correctly, you don't need to necessarily do a new one. The new ones are really for any new hires. Now, the caveat there that I would bring up, the only caveat that I would bring up with regard to that is this. If you don't have all of your new hire forms, right? Let's say you're in a state and you only have 3 or 4, you don't have, you know, at least 12, because that's the minimum depending on where you are around the country. If you don't have all of them, it's not a bad idea to get all of them and update it all, right? To update it all. Then in that scenario, you know, you're giving them all the new hire forms and you're having them update all of them, and that's okay and probably good practice, so that you don't miss anything. So you know, it is a little bit of a pain to have them do it all, but well worth it to make sure you're super compliant. So, all right. Okay, let me see. I can see some of them. I think Lauren's answered a lot of them already. I have one other question is, I know Washington usually follows California. Are there any Washington updates, Washington law updates that need to be had? You know, we will follow up with you directly on that if there are anything that we needed to talk about. If it wasn't in the presentation, there may not be anything that's, you know, there's always law updates, but there may not be anything that's specific to medical dental practice that we think, you know, may be relevant. But I'll have the team follow up with you if there's anything that we think you need. Okay, all right, Taylor. I think that's it. Everyone else, if we didn't get to answer your questions online or right now, we will follow up with you. We have your information. Feel free to, you know, ask it as well. If you want to send an email to hello@hrforhealth.com with your question, we will, if you didn't ask, if you asked it anonymously, we will reply to you directly. Okay.
Awesome. Thank you, everyone. We will send you the slide deck, all of the QR codes, and all of the resources that you want to send out to friends, coworkers, colleagues, anyone at all. We will be following up with you within the next hour with all of that information. So please check your emails today, and thank you all so much for being here.
Yeah. Have a great Thanksgiving, everyone. Take care.